May it please, my lordship. Item number 14, kindly pass over the matter for that day.
You are Mr.
M. Rahman.
40 appellant, you are 40 appellant.
No.
You are for the appellant.
Yeah.
No, my lord, I am for the appellant in item number
I'm
15.
up.
Respondent.
You are the respondent.
Yes.
Respondent number?
Yes.
I have no idea, nothing. Who is the respondent number?
There are 8 respondents. I don't know what he is looking for.
Your good name, please.
TU Lascar, my lord. I am-
Heard Mr. T.U. Lascal and the council for the appellant. Also heard MSS John and the adjutant P.P. Assam. On request made on behalf of Mr.
M. Rahman.
You are making your
I am on behalf of A. Tapadar.
on request made on behalf of A.S. Tabatel and the council for the respondent. Please the matter after 1 week, 1 week or 2 weeks?
2 weeks. 2 weeks.
2 weeks.
2 weeks. Applies.
No, please, Lordship. My lord, I filed an appeal against acquittal, my lord, but it was not been listed since 2022, my lord. After notice, it has not been listed. So may I pray, my lord, may come up any day next week, my lord.
May I please, your lordship. Lordship, I beg to mention for listing of one IA, lordship. We have filed on 10/4/2023, lordship. Till today, the IA for lordship suspension of sentence, lordship, on the ground of juvenility, lordship.
Next week.
Next week, lordship. Oblige, lordship.
Item 1, 2, and 3, admission.
Yes.
Please, your lordship, before my learned friend starts the case, my lord, I just want to point out 2 things, my lord. One is that, my lord, 2023, 7th of May, the exam will be held for 2023 based and results will be on somewhere in the month of September, October. This is one, my lord. Number 2 is that my learned friend, before my learned friend starts on the judgment, which is relying that there is a rule which we made in 2016, and that was set aside on the basis of a judgment of the apex court, 5 judges E.V. Channaya's case. There cannot be any classification, sub-classification or micro-classification among the ST or the SC. So on the basis of the E.V. Channaya, the rule which we have made and the division bench in 2016 rule which were made was set aside. Now thereafter, there is another judgment of the Supreme Court, the 5 judges bench, same Devendra Singh judgment. They said that they differ. They said that no, there can be a sub-classification. Sub-classification can be made by the state. So one of the paragraph, my lord, they said that Punjab, in state of Punjab, there is a sub-classification which is made by the state in respect of ST and ST. So now they said that no, we respectfully, they doesn't want differ, and it was they cannot revisit E.V. Channa, and it was referred to the Honorable Chief Justice to place it before a larger bench. So that is the issue, my lord. So if it is not a case where there is a judgment of this division bench and relied on E.V. Channaya's case, so that has to be looked into it. If that is to be looked into it, then there is other aspect of the matter is so far as the percentage of reservation. If we can make sub-classification, if that is to be held, then to what extent? So these are the issues, my lord. I just want to place it before your lordship.
But that
So
is on the
whether-
merits of the case. I'll argue. Let my learned friend also argue.
Yes.
Well,
this is-
merely because the judgment is referred, that does not mean the Channaya's law has been overruled. Supreme Court says, my lord, until and unless, maybe, my lord, coordinate bench has differed with a particular view. Now the matter has been referred. Now, until and unless the larger bench overrule Chennaya, the Chennaya law principle will continue to govern the field. That's the law. It's a very simple case. My lord, my learned friend, I do not know, but we are concerned with the current, my lord, selection for the current year.
You've got your admission?
No, one of the petitioner got it, my lord. In fact, it was offered to two of the three. And the second, she already joined some private college, therefore she did not join it. That way, as far as the past transactions are concerned, that is okay. Now we are concerned with the current admission, my lord, where the exams have started, my lord. On 28th of April, it has already started. So, my lord, very soon they will announce the date for, counseling and all. Again, same thing will happen. And for the earlier years, my lord, despite order of this honorable court, they never give admission, my lord. So therefore, my lord, there is great sense of urgency as far as the petitioner is concerned.
My lord, we have already to your lordship that we have written the government of India, ministry, and ministry account is given accordingly.
No, my lord, that is over. I am not on that. I am not on that. Lord, my lord, it's a very simple matter, my lord. Only thing is the issue is covered by particular judgment of this honorable division bench judgment. And my learned friend's contention is the division bench relied upon X judgment, and X judgment now is referred. Well, until it is overruled, that judgment is the law of the land. I don't think there is any difficulty in appreciating that proposition of law.
With great respect, I'll say there is no such judgment because it will never happen in Supreme Court. If there is a 5 judges, hearing of the 5 judges, Supreme Court has not decided that issue. In
No,
one
it
of
has
the
decided. I'll place
no,
it.
in one of the Bombay High Court, they have decided. Let me, my learned friend.
Well,
because
there
this
is
will
a
take
judgment
some
of the
time, my
Supreme
lord.
Court where Supreme Court has said merely because a decision has been referred, it does not mean it stands overruled. It will continue to hold the field until such time the judgment is overruled.
Same issue, same point. It has been same issue is same.
Advocate General,
Yes.
are you ready to argue the matter or you want the date deferred?
No, I just want, my lord, a date to be deferred if
No,
it's
no,
not
no.
inconvenient, my lord. So let it be a date because there is no, because we have given admission. One particular, my learned friend.
No, my lord, I have already
That's
explained the position, my lord. Because of the current admission, again, we will be land up in the same problem. My lord, why my learned friend doesn't appreciate my lord?
Classes started in the month of November. November 2022 already started.
So when is
And there is already
when is
interim
the
order.
exam concluding?
Already started, my lord.
It started 2022.
When is it concluding?
I'm sorry.
Today the selection process has started. Today is the exam. State exams, today.
NEET examination is on 7th,
Huh?
my lord. NEET examination is on
And
7th.
NEET next week, my lord.
7th of May 2000 for 2023 batch. My lord, 2023 batch with the result will be declared somewhere in the month of August. August.
My lord, the
my lord,
matter
he is
has come up
protected.
for hearing after a long
Admission.
adjournment.
Admission.
Why my learned friend is opposing that? I
It's
don't
not a
understand.
question. There is not a question of opposing.
Correct.
Whatever the prayer which has been made by you for getting a seat, already you got a seat.
Oh, no,
There
no,
were
no.
three, there were interim order was passed on 6th of January 2023. 3 seats, my lord. We said, okay, 3 seats had fell vacant. One we accommodated. Second
My
one.
learned friend is not appreciating. It is my writ petition. He is standing for the other side. My lord, kindly see it's a case of which year? 2021. My lord, this rule is being challenged in this PIL, my lord, and that is being heard from time to time. And now the understanding is lordship will dispose of the main case, and it's a covered case. It doesn't even take long time. But you will kindly permit me to place my case, my lord. My learned friend is making argument on merits that lordship will consider.
Merit, my lord. My learned friend is saying that he will rely because it will not take much time because there is one judgment of the Supreme Court.
Yes.
No, because anyhow.
One thing is, I'll make it clear.
Yes.
7th is the deadline.
Yes.
Correct.
Yes. 7th of May.
If a date is to defer, this has to be heard before 7th.
Yes.
That is what I'm.
It's okay, then fix it on 5th or whatever your lordship wishes to fix it.
No, my lord, today what is the difficulty of my learned friend?
All India examination for the year 2023 entrance examination. They have to sit for the examination 2023. They want to get into admission, my lord.
My lord, they will make the
2020,
selection based on the rule which is under challenge, which is a prima facie unconstitutional. Because there is already pronouncement. That is our grievance, my lord.
So, my lord, 7th of May 2023 is the exam, NEET examination for the batch of 2023, where this result will come somewhere in the September. There is absolutely no difficulty. There is interim order.
No, my
is
lord,
protected.
why the matter
Also,
should not
what
be
is
taken
your
up today? I am on that. My lord, it's a
Yeah.
2021 matter. We are talking of pendency of cases. Why are we seeking adjournment, my lord? It's item number 1. Let us do it, my lord. With all respect, I am submitting. This is not a very longish matter. My lord, my learned friends concerned, that judgment I am asking, it is being brought, my lord. There is a clear judgment of the Supreme Court. Merely because a judgment is referred, that does not mean the judgment under reference is overruled. That effect will take place only when, my lord, it is overruled. Until then, the law laid down in Chennai will continue to govern the field. It's a different bill. Tomorrow, my lord, if law is, that's why, my lord, why it is said, merely because there is a change of law, review does not lie. Why it is incorporated in CPC? That is the reason.
If Advocate General has a difficulty today,
Yes.
then we can.
If my learned friend has any personal defect, that's it. But he is making argument on merit.
No, I am not on merit.
If you
I
have some
am not on
difficulty-
merit,
if
my
you
lord.
have some
Yes,
difficulties
some
there-
difficulties there, but I am not arguing on merit. Because my learned friend is saying that within 10 minutes, he will finish off this matter.
Yes.
Because there is one judgment, EV Chennai, and it is hold good till it is not been, it is decided by, it is decided by larger bench. But the issue is the same, what I am saying, my lord. In Devendra Singh, issue was the same. And that is, I could have very well understood. But the judges, 5 judges, Devendra Singh also 5 judges.
Oh, my learned friend is not
Yes.
getting me. What I am saying is, my lord, his contention is division bench relied upon a particular judgment, which a subsequent coordinate bench says, doubted the correctness, therefore it has been referred. Therefore, my learned friend wants to perhaps say that court should not hear the matter. To that, my answer is, my lord, merely because a judgment is referred, it does not mean the, my lord, Chennai's law is overruled.
I've
Saying
got
there
your
is a
point.
judgment to that effect.
I've got your point.
If my learned friend has any personal difficulty today, if the matter is taken up on Monday, that's a different aspect. But it has to be heard before 7th of May.
Yes, Advocate General,
Sorry, Tuesday.
Monday is a holiday.
Oh, sorry, my.
Except 7th of May 2023 is the date of sitting of an examination will be held for 2023. Somewhere it can be somewhere in the May also, 2nd week, 3rd week, your lordship can fix this matter. I think.
Then, my lord, since state is taking time,
Yes.
the exam which will start, they will not declare the result. The state exam which is being held today, they will not declare it because state is taking time.
Result is in August, my lord. August 2000.
All right, till the matter is heard, they will not declare the result.
How can be my result? Central exam, my lord. It is not our exam.
No, state exam, state exam.
No, not the state. It is on 7. All India exam, NEET, my lord. It is all India.
No, state exam result, they will
NEET
publish.
is all India, my lord.
My lord, there are 2 exams, my lord. One is, they call it SMATEE, that is being held today, and the NEET will take place on 7th of May. What I am saying is, since state is taking time, the exam which state has commenced today, the results of that will not be declared.
But that is not an MBBS,
Then, my
my
lord,
lord.
they
It is smarty.
urgency will be on their part to do
That
the
is
case.
smarty, not an MBBS, my lord. It's a smarty, not MBBS.
Then we'll have it on 4th of May. So this is a hearing day.
Yes.
And if it cannot be, if it cannot be heard, maybe we'll consider the prayer for interim.
My lord, that's not an MBBS exam. You are concerned of the MBBS. Pharmacist, my lord, that's not MBBS. Let us understand ourselves. MBBS is a NEET, my lord, which is, my lord, all India level on 7th
Oh,
of
the
May
exam that you
2000.
are having today is
My lord,
pharmacist.
No, but that's
My lord,
different altogether.
my lord, my learned friend is not understanding, my lord. It is the same rule which will be applied whether it is pharmacist or MBBS.
But it's
The rule is same.
but my learned friend is not appearing for
MBBS,
pharmacist.
whether it is pharmacist, whether it is engineering,
That's why
the
I'm
same
saying, my
rule.
lord, 7th of May 2023 is for the All India Examination of Medical, my lord, MBBS. This is pharmacist, my lord.
My
nothing to
lord,
do.
merely
That's why
because,
I'm
merely
asking.
because the exams are away, therefore that
No,
cannot be a
see,
ground
my
for
lord, I
adjournment.
am not asking,
Lord,
my
we
lord,
have
I
to-
am
we also have a
asking second
responsibility,
week or
my lord.
3rd week of May, I am asking. So nothing happened, the 2nd week or 3rd week of May. Some difficulties are there, so I'm asking, my lord.
Yes, Chowdhury, what do you say?
2nd week, I am asking, my lord.
No, my lord, then in that case, the exam which has commenced today, the result of that should not be
No,
published.
that, when are you?
This
When are you pronouncing the results?
So no, we have to take instruction, my lord, on that issue, my lord.
Get
How
some
can I?
get
And
some
these are what
instruction.
I have been told as a pharmacist, my lord. We have to take instruction
Yes,
on
yes,
it.
yes. My lord, this is a discipline in agricultural science, animal husbandry, veterinary science, medical science.
So,
These are the four tests.
not MBBS, my lord, not MBBS.
Medical science, it includes
Medical
pharmacists
science.
also.
No, we can't. How can we, my lord? I can't just say like that, my lord. These petitions are for MBBS, my lord.
That I know.
Yes, that's why.
No, it's not for MBBS,
Yes.
my lord. It covers everything.
MBBS, my lord.
Look, we have challenged the validity of the rules.
Third week of May, my lord, I have absolutely no problem, my
So
lord.
when are you declaring the results of today's exam?
Huh.
We don't know, my lord. I can't say just now, my lord.
Can you get some instructions?
Yes, you can get the instruction, my lord.
Then we'll.
Yes. Only thing is, my lord, if state is taking them, then some protection should be given to us. My lord, we have challenged the various of the rules. Therefore, anyway, my lord, there's nothing to submit on that way. Only problem is something was in the context of MBBS, not in the context of other education. And another one aspect on merits, my lord. Now, Mizos are the dominant class. Now, my lord, where is the question of making reservation for Mizos, my lord?
My lord,
Lordship knows,
oral
in
instruction.
legal terms, we say,
Oral instruction is you will give it 3 weeks. 3 weeks.
Ah.
Smarty results, Smarty.
they will not declare the result, my lord.
Smarty, 3 weeks, my lord. Why unnecessary, my lord? 2 weeks.
So
Lordship, no, Lordship will record that statement. That's why Lordship is fixing on.
Oral instruction, my lord, 3 weeks. That's what instruction on telephonic instruction.
Hurt Mr. Kian.
But there is one aspect, my lord. I'm very sorry to interrupt, my lord. In such a situation, my lord will not be able to, my lord, sit in the exam for the counseling.
No, we'll have it heard.
Hmm.
We'll have it heard.
Huh.
Heard Mr. Kian Chowdhury, the senior counsel, assisted by Mr.
My lord,
The Chakma.
D. Chak.
my lord, before you dictate the order, may I please one submission?
Yes.
My lord, I am the counsel for in IA. Actually, my lord, here the as part the order 6/1/2022, there are 3 seats were allotted to Monica
That order
Chakma.
has been modified.
My lord, actually, what I wanted to say is that she declined. That petitioner number 2, she declined. So now 1 seat is vacant. So my lord, we are really expecting the AG to make submission. I also requested the AG. Actually, that 1 vacant post may kindly be filled.
My lord,
That
let my
order-
learned friend file an independent writ petition. Let him not get any
My lord,
relief in
accept
our
it.
petition. This is our writ petition. As an OP, he cannot seek relief.
Lalun Sanga, the order of 6/1/2003,
Hmm.
Yes.
23,
Yes,
that has been modified by order dated 31/2023.
yes,
Is it 31? No,
yes.
where they said that either you or the number 3, who has
Yes.
the higher marks, will get admission.
Yes.
That's it.
Well, look, actually, after that new development is that number 2 declined. 1 is still vacant. So the highest mark may kindly be considered by the state.
No.
File a writ petition.
File a writ petition, not in our petition.
My lord, at least liberty be filed in Aizol bench because the last court did, petitioner council also submitted this is another independent course of action. At least liberty be given to file. At
No
least-
liberty is
What
required, my
liberty
lord.
is required, only the order is
My
that-
lord,
that
if
you
we
can
file
it.
Aizol, they might say that it is pending in Aizol or Guwahati.
We will not be there to oppose my
At
learned
least
friend. Somebody
liberty-
else will be there.
If there is liberty, that will be appropriate.
Lalun Sanga, let us be little bit reasonable.
Yes.
Heard Mr. Kian Chowdhury, Learned Senior Counsel, assisted by Mr. So and so for the petitioner. Also have
Hari-
Mr.
Hari-
Das, the Advocate General Mizoram. Anybody for any other respondents? Mr. A Talukdar for respondent number?
No, it's for the existing.
Oh, assisted by A Talukdar.
In the behalf of the
For Mizoram. Then
Monday করিব পারি
Gogo is there?
second month
No Gogo.
বিধান করি
JC Lalu Sahal and counsel for the applicant in IA civil number 468 and 469 of the statement. Mr. D Das, Leonard, Advocate General, Mizoram, submits that the results of the examination that is being held today. What exam is it?
My lord, state
IES.
state SMATEE 2023. SMATEE 2023.
Will not be declared for 3 weeks, correct?
That's a real instruction.
Will not be declared for the 3 weeks. Accordingly, recording the statement of the Leonard Advocate General, release this matter for final hearing. For admission hearing,
Admission hearing.
when do you want?
Let it be on 10th, my lord.
Second week,
Second,
10th, my lord.
give a date, confident date.
10th of May, my lord.
10th of May is a Wednesday.
No problem, my lord.
let it be on Thursday.
Let us-
Thursday hearing, let it be on Thursday.
Any date,
Thursday hearing date.
11th,
11.
11th May.
Deeply obliged. I'm keeping this, huh? And that's, next time I'll take the judgment. No, no, no. What I said is when there is a reference.
That is item 1, 2, and 3.
Four, order.
In this matter, your lordship, Miss Bhuya has filed the objection. So she'll come if your lordship takes it up after some time. She is legs on some other court. After some time.
Five,
May I please, your lordship? My lord, this is a jail appeal. On the last occasion on 30/1/2023, your lordship had called for the LCR. Those have been arrived.
Yeah, B. Prasad,
B. Prasad, am I?
B. Prasad, Leonard, amicus curiae. Also heard MSS Jahan, Leonard addition to the Assam. LCRs have been received. Ministry is directed to prepare the paper and list the matter. 4 weeks or 6 weeks is convenient for the registry.
4 weeks, lordship can give it now.
4 weeks.
After that, lordship can extend.
six,
6, I don't know, there's some mistake. I thought that I filed my objection, but it's not in records, I'm told. So I'll just check, lordship will give me 1 week's time. If I have not filed, I'll file it. 1 week's time.
Your MS, NM Deca.
NM that.
Third MS, NM Deca, and counsel for the applicant. On request made by MSS Jahan and additional people, list the matter after 1 week. Yes.
seven,
May I please, your lordship? My lord, this is the IA for continuation of delay, my lord, of 2,250 days, my lord.
2,250 days.
Basically, my lord, he was initially acquitted, my lord. Thereafter, my lord, it rejected a criminal petition by somebody else. That matter went back to trial court, my lord. Accordingly, trial court has convicted. Then, my lord, there is a state liabilities also there, my lord. Jail appeal should have been preferred because it was a life sentence, my lord. And to that effect, my lord, I have given, my lord, elaborate explanation in para 2, my lord, that why I could not file, my lord. Lost my father, my lord, and I am behind the bar. No bail, nothing has been given. And no one apprised me, my lord. There is statutory right is there, my lord, as per the jail manual. That also been not considered, my lord. That has not been apprised to me, my lord. And that part, my lord, they have admitted in their objection, my lord, that what are the grounds I have taken, my lord. Considering that, my lord, the delay may be condoned, my lord, because from the judgment I have seen, my lord, there is no even 313, my lord.
You are blaming everything on your father and your brother.
No, madam, not, no one is there, my lord. Nobody visits me, my cousin, my lord. And lordship is aware, my lord, I do not have my own brother. Or my cousin, my lord, they never apprised me, nothing, my lord. Coincidentally, my lord, one of his relative apprised a lawyer. Then he engaged me, my lord. That happens. And
Yes,
for,
Jahan,
I filed one objection to this. It's on record. What he is saying that,
objection.
yes, what 2000 so many days, Lordship, 2250 days. That is around 9 years. And of course, what your Lordship had said is the blame was entirely on the father and the brother who did not communicate, or who
including
did
jail
not
authority, my
give
lord.
the documents to the council. So he was a constable. He was a the case was under the Arms Act, and he was a constable or what? He was
Constable,
huh?
constable.
Constable. He will not know the nitty-gritty of law, but then still 9 years delay is little too on the higher side. And what I have stated in my petition is this is not an application under 383, not a jail appeal. He should, the superintendent under the Assam jail manual should have immediately informed. And then they will take the steps.
This is
This
not
is
an application, not a jail appeal.
not a jail appeal.
Jail did not prefer the appeal, my lord. They, if jail should have been preferred as per the jail manual. And I became the unfortunate victim, my lord. Jail authority ought to have filed an appeal.
He was convicted for killing the deceased in a cinema hall. As far as marriage is concerned, there was no eyewitness, and the only evidence that was put forth is that the empty cartridge that was found at the place of occurrence did not was examined and was found that the same was fired from the rifle that was allotted to him. That was the only ground on which he was convicted. Of course, he was inside the jail. Perhaps he
What
could not
about, my lord,
communicate.
313, my lord? 313, my lord, it is not part of the job of the learned trial court, my lord, to record the statement under 313. It is not been recorded so far judgment is concerned. So
Because in
my
the
prayer is
meantime,
that, my lord, my prayer is that, my lord, lordship condone my delay and fix the matter for appeal, my lord. Lordship will examine what is what, my lord. If I am entitled, entitled. If I am not, not, my lord. For the sake of, my lord, limitation,
Jahan, are you seriously objecting or?
Lordship can, since it's an arms act and all, Lordship will hear the matter.
Yes, it's better.
okay, my lord. At least one
Yes.
opportunity, my lord, should have been.
Yes, yes. Father died and the brother could not do it. So it
Known brother, cousin.
In the eye. Heard Mr. J.I. Barbuya for the applicant. Also heard MSS Jahan and in addition to yes. By this application, the applicant is praying for continuation of 2250 days in filing the connected criminal liability. The explanation is made at para 2 of the present application. On consideration of the explanation made, comma, we are satisfied with the same. So, do you have any objection? No.
Lordship will write that I have filed my objection petitions as well.
MS Jahan, then the counsel on the basis of objection filed submits that the delay of 2,250 days has not been explained properly and therefore therefore the present application may be dismissed. Stop. After hearing for the parties and on consideration of the cause shown, we are satisfied accordingly. The delay of 2,250 days in filing the convicted criminal appeal is condoned. Stop. Registry is IS disposed of. Registry is directed to number the criminal appeal and list the matter in its usual course.
Next week, my
Usual course.
Not.
cost, my lord, you cannot, my lord. Even lawyer also, my lord, of my own, my lord. That's no I said, my lord.
It will come in his usual course.
My lord, let it be, my lord.
We have condoned 2,250 days. They wait for them.
My lord,
Should be satisfied with that.
lordship.
8, hearing.
Lordship, that part heard matter.
Oh, we requested you to get some.
Yes, citation as regards reflection timing, your lordship. I found 2-3 judgments by note. I'll place it, your lordship. No, office de no junior business. First of all, one Shankaria judgment, your lordship, 1978 3 SCC,
19.
73 SCC 435. Paras 39 to 46. I'm giving the citation. No, Saita Commission is not more. The tomorrow is Saita Commission. Lordship, para 39.
Yes.
It is true that the interval between the preliminary examination of the appellant and the recording of his confessional statement was about 15 minutes, but there is no statutory provision in section 164 CRPC or elsewhere, or even an executive direction issued by the High Court that there should be an interval of 24 hours or more between the preliminary questioning of the accused and the recording of his confession. The condition precedent for recording confession by the magistrate in the course of police investigation is provided in section 164(2) CRPC, which mandates the magistrate not to record any confession unless upon questioning the accused person making it has reason to believe that it is being made voluntary. In the instant case, the magistrate fully complied with the condition. He, Sri Bansal, has testified that before recording the confession, he had fully satisfied himself that the accused wanted to make the confession voluntary. The large number of clear and pointed questions put by him to the appellant for his purpose and answers given by the latter have been extracted in full earlier. The perusal shows that the magistrate had chosen reasons to believe that the confession was being voluntarily made. Although the interval between the preliminary questioning of the appellant and his confession was about 15 minutes, the appellant had not less than 38 hours at his disposal. Whilst he was in judicial custody free from fear or influence of the police,
to think and decide whether or not to make a confession. As noticed already, the appellant was brought from Ganganagar to Raising Nagar on June 12, 1974, because on that day, no magistrate competent to record the confession of the appellant was available at Ganganagar. The appellant was admitted to the judicial lockup, Raising Nagar, under the orders of the magistrate about or after 4 p.m. on that day. Thereafter, the appellant continuously remained in the judicial lockup or judicial custody till his confession was recorded in June 12, 1974, from 8:45 a.m. onwards. The magistrate Shri Bansal was aware that the appellant was continuously in judicial custody since the evening of June 12 or for about 38 or 38 or 40 hours preceding the confession. Lordship, then paragraph 43, in Sarwan Singh versus State of Punjab, this court has emphasized that before recording a confession, the magistrate should see that the mind of the accused person was completely free from any possible interference of the police. In that context, it was observed that the effective way of securing such freedom from fear to the accused person is to send him to jail custody and give him adequate time to consider whether he should make a confession at all. In this connection, it was suggested, speaking generally, it would, we think, be reasonable to insist upon giving an accused person at least 24 hours to decide whether or not he should make a confession. The court was careful enough to preface this suggestion with the remark that it would naturally be difficult to lay down any hard and fast rule as to the time which should be allowed to an accused person in any given case. It will be seen that how much time for reflection should be allowed to an accused person before recording his confession is a question which depends on the circumstances of each case. The object of giving such time for reflection to the accused is to ensure that he is completely free from police influence. If immediately before the recording of the confession, the accused was in judicial custody beyond the reach of the investigating police for some days, then such custody from its very nature may itself be a factor dispelling fear or influence of the police from the mind of the accused. In such a case, it may not be necessary to send back the accused person for any prolonged period to jail or judicial lockup. In the instant case, the accused got admitted to the judicial lockup on June 12 for getting his confession recorded under 164 CRPC, and such admission was made under the orders of the magistrate who ultimately recorded his confession on June 14. The accused was about 2 days in judicial custody beyond the reach of the police. On June 13, 1974, a written request was made to the magistrate by the police for recording the confession of the accused. Even then, the magistrate postponed the recording of the confession till the following day, obviously because he wanted to give the appellant 1 day more in judicial custody to ponder over the matter free from police influence. On June 14, notwithstanding the fact that the accused Shankaria was in judicial custody from the evening of June 12 after the preliminary questioning, the magistrate allowed 15 minutes more to him for reflection. Thus considered, Shankaria had, as a matter of fact, about 13 or 40 hours in judicial custody immediately preceding the confession, and this was rightly considered sufficient to secure freedom from fear or influence of the police to him. The facts in Sarwan Singh versus State of Punjab were entirely different. Therein, the accused who had visible marks of injuries were straightway brought by the police from its prolonged custody and produced before the magistrate, who immediately thereupon recorded his confessional statement, while the police sub-inspector remained outside in the veranda of the magistrate's office. The magistrate did not ask the accused how he came to be injured. It was in these circumstances that this court held that the failure of the magistrate to give adequate time to the accused to consider the matter stamped it as involuntary. The facts of the case in hand are substantially in line with those of Abdul Razak versus State of Maharashtra. There, the accused escaped after his arrest in police custody for a fortnight. Then, after being kept in jail custody for 3 days, he was produced before the executive magistrate for recording confession. The magistrate, after warning, sent back the accused to jail and then recorded a confession on following day, repelling the contention that the accused remained in prolonged police custody and his confession was not voluntary. This court held that the accused has spent 4 days in judicial custody and he was not under the influence of the investigating agency for the last 4 days. For the above reason, we negate the third point canvassed by the Mr. Gambhir. So there is no specific rule, my lord, that the point of lordship the time should, as regards the time, as should be given to the accused person for reflection, my lord. In our case, only 3 hours have been given. Those, I think it's enough, my lord. Time for reflection. My. I'm thankful to my learned friend. She has provided me with this judgment. My
Was
lord.
he in judicial custody at that time?
He was. He was.
Since?
He was, right? He was not? I'll check, my lord. I'll check. Let me see the evidence of the PW7, my lord.
इसमें by the way,
PW7.
मैंने अपना खुद
Because in his deposition, the SDO's deposition, he was produced, my lord, on that day accused so and so was produced before me in connection with Bokolia PS. I'll see, my lord, the records. Twenty-four 40.
Lordship is at page 58. 58 and
5-8.
58. On 24/4, he was arrested on 23rd. He was produced on 24th before the magistrate. Your Lordship will find the order there. Accused person, then he was remanded, but on the same day, there was a prayer for confidential recording of confidential statement. And if your Lordship then see the page 60, 59 is the form of the confidential statement. So on 24, so on 23rd, he was 29, second, on midnight, the incident has happened. 23rd, he was arrested. So he was in police custody till 24th. He was produced before the magistrate on 24th. And on the same date, if your Lordship sees the page 60, on the
Yes,
right
my
hand
lord,
side,
he was
12.
24/4. I have
12.
seen the records.
Huh.
Accused Matka Munda so and so is produced before the court under arrest by Bokolia PS, seen the forwarding report and other so and so accused were remanded to jail hazard till 11/5/09. It was the order of 24/4/09. So he was produced from jail.
And on
The
the
time of reflection was given.
and if your Lordship see page 59, 59, 58 is the order of the magistrate. 59, from the magistrate court, he was escorted by police. The accused brought by Havaldar Munindra Kumar Hazarika. So he was still under police custody. Till that time, he was produced before the magistrate for recording of the confession on the same day. So from police custody, so there was no judicial custody in between. From straight away from judicial police custody.
Police custody.
Yeah. Yeah, let my senior friend complete then.
Lordship, there are other judgments I have brought, my lord. 1975 SCC online, 111. Para 14. 1975 SCC online, Odisha 111. Para 14. The next piece of evidence is the judicial confession made by the accused persons before the magistrate PW2. The accused persons have confessed to have killed the deceased, but say that they did so as the deceased started abusing them in obscene language. The explanation or justification for the assault being somewhat exculpatory in nature and for reasons already discussed in connection with the extrajudicial confession being unacceptable as true can be discarded, and the inculpatory part of the judicial confession can be relied on in absence of any other infirmity in the same. The confession, however, was held inadmissible in evidence by the session judge on the ground that sufficient time had not been given to the accused person for reflection. The same ground of attack also is repeated by the defense counsel here. It appears from the evidence of PW2, the magistrate, that the accused were produced before him by police at 12:30 p.m. on 11/4/72. He disclosed his identity to them, and after warning them that whatever they might say may be used against them, gave them time for reflection till 4 p.m. Again at 4 p.m., he repeated his warning and thereafter recorded the confessional statement according to the session judge. The time of 3.5 hours given to the accused persons for full reflection was not sufficient, and that they should have been given at least 24 hours, as is indicated in a Supreme Court case reported in AI 1957 SC 637, Sarwan Singh versus State of Punjab. I do not think that whatever the Supreme Court said in that case was a rule of law. There is no universal rule as to the extent of time to be allowed for cool reflection to the accused persons desirous of confession. Till that part, I'm relying. Lordship, one more judgment, 2005-10 SCC 453. Para 5, man. I'll not be reading, my lord. I'm just passing judgment. Para 5, man. 2005-10 SCC 453. Devi Singh versus State of Rajasthan, Para 5. Lordship, the second page, 455. The appellant the appellant was produced in court at about 12 o'clock, and he put the preliminary questions and recorded the answers of the appellant. Thereafter, the further confession statement was recorded at about 2 o'clock. The appellant had time for reflection, and the appellant was during his period in judicial custody. It is also pertinent to note that the appellant had given detailed recording as to how the incident happened. It is stated that the co-accused came to him in the evening and offered him rupees 1,000 in cash and a gold chain in his consideration in case he would do away with the brother-in-law. And he further stated that he, along with the co-accused, went to the Hera and boarded a bus of Sadri and reached Gomti at about 4:40. And thereafter stayed 3 hours so and so. Lordship, so in this case also, your lordship, only few hours have been given, your lordship. Detailed description have been, he was made understood, your lordship, about the consequence, your lordship. He was given time for reflection. So that is enough, my lord. In our case also.
He was under judicial custody.
No, after he was produced, he was under judicial custody, my lord.
No, read it. The fourth line.
The appellant had time for reflection, and the appellant was during this period in judicial custody. So Lordship, hmm? আমারতো 3 ঘন্টা দিছে। হুম। Lordship, I'll take your Lordship once again to the confessional statement at page 68 once again. Page 68. Yes, of the paper book.
Yes.
Lordship may see the timing, my lord. Page 59. The accused brought by Havildar Munindra Kumar Hajorika, Bokolia PS. Down below, my lord, page 59.
Yes.
Yes, my lord. He was brought. Then, your lordship, court on 24/4/09, office at house at 12:30 AM. Court number 35, case number 35/09 under section so and so. Confessional statement 24/4/09. So, your lordship, it was at 12:30 AM, your lordship. Recording.
3:30.
So, lordship, he was brought, my lord. If your lordship sees,
Statement to 3:30.
page 59, page 60, 12:30 AM he was brought. So it was recorded at 3:30 PM. So, your lordship, during that period, he was in judicial custody. He was inside along with the judge, my lord. He was not under the influence of police. Nowhere it has been stated, my lord. And he has not taken that plea, my lord. Lordship, am I clear? And regarding the, one more aspect regarding the injury on the spleen, my lord. I've got one judge. Probably he also referred one Assam High Court judgment. No?
That been very moody.
Okay, notice. Criminal Appeal 185, 1986, my lord. Para 11 till para 20, my lord. So he has taken a plea
Para?
para 11 to para 20, my lord. Para 11. In this connection, adverting to the evidence of PW9, Dr. D.K. Ramawat, who has performed the autopsy, has inter alia testified that the injuries of other than caused on spleen were not sufficient to cause death of disease in the ordinary course of nature. Size of the spleen of a normal healthy man is so and so. Spleen of the deceased was 1.5 times in size than the spleen of a normal man. The multiple fracture of ribs number 7, 8, and 9 of deceased were linear. When the spleen of the deceased was examined, no bone was found therein. If the spleen of a man is enlarged, then on coughing, falling down on account of slow stroke, or forced vomiting, rupture is possible. The spleen of normal size remains below the ribs, and on its becoming enlarged, it may come out of ribs and due to enlarged become soft and chronicle. The postmortem report in its column number and mention is under spleen, rupture of spleen is present. So next parameter, so far as the cause of death is concerned, according to the opinion of the Dr. PW9, deceased died due to hemorrhagic shock caused by rupture of spleen. In view of aforesaid evidence of PW9, Dr. Ramawat, who conducted postmortem and prepared autopsy report, there is no manner of doubt that the deceased was having an enlarged and diseased spleen half time more than the size of a normal spleen. Thus, we have to decide which offense is proved against the accused, that is murder, culpable homicide not amounting to murder, grievous hurt or hurt. As per Modi's medical jurisprudence and toxicology, the normal spleen is an adult measures 12 into so and so. In some cases, the spleen decomposes earlier than the stomach and the intestine, especially if it is swollen and hyperemic from an acute infectious disease or enlarged from chronic malaria. However, it may resist putrefaction longer if it happens to be firm and comparatively bloodless. Owing to putrefaction, the spleen becomes soft, pulpy, greenish steel in color, and it may be reduced to a diffluent mass within 2 to 3 days in summer. On account of a situation, rupture of a normal spleen is very rare unless caused by considerable crushing. Your lordship will kindly note that part. A grinding force such as the passing of a carriage or motor car over the body, or by crash in a railway accident, or by a fall from a very great height. In such cases, it is usually associated with injuries to other solid organs and the ribs overlying the spleen. A normal spleen may sometimes be ruptured by the broken ends of a rib, which may be fractured by a severe kick. Your lordship will kindly note that part. Severe kick or by a blow from a blunt weapon. So in our case also, stick was used by the accused, my lord, which in his 164 statement he has stated, my lord. A spleen subjected to traction forces may be torn from its pedicle, and enlarged spleen becomes softened and brittle. Hence, it is liable to rupture from fall or from violence of a very slight degree. In such cases, the abdominal wall may not show any external mark of injury. As per Dr. Jhala versus and Raju's medical jurisprudence, normally the spleen is very high up in the abdomen and well protected by the ribs. Thus, unless enlarged to double in size, it is not directly exposed to external injury. Penetrating injuries can certainly involve the organ. When enlarged, it is clearly vulnerable even to direct blows like kicks. Furthermore, such an enlarged organ is fragile in structure and hence likely to bleed profusely. Such profuse bleeding may prove fatal, and that too rapidly so. On the other hand, when the spleen is of normal size and texture and found to be lacerated, the overlying side and abdominal wall must show signs of blunt injury, which is contusion. A kick or an enlarged spleen resulting in fatal hemorrhage amounts to a milder offense, even of simple hurt, depending on circumstantial evidence. In view of the above referred to authoritative passages on science of medical jurisprudence, it cannot be gainsaid that enlarged and disease spleen itself is sensitive and it is vulnerable and susceptible to rupture by a slightest force. Now, therefore, the question which requires to be considered is as to whether the accused have committed the offense culpable homicide not amounting to murder, punishable under so and so, or grievous or punishable so and so. Then, my lord, para 17, a similar question arose before Calcutta High Court way back in 1920 in the case of Emperor versus Severally Sarkar, AI 1920, Calcutta 401. In that case, the accused, having found that a young man had had approached his kept mistress for the purpose of having so and so with her, thought that he would be justified in teaching him a lesson by giving him a good thrashing. He accordingly sent for the brother of a young man, and in the presence of the villagers gave him a good beating by kicks and blows, which resulted in his death. The deceased was of a weak constitution and had an enlarged spleen, and it appeared that when the villagers told the accused that he was about to kill the young man by his kicks and blows, he observed that the deceased was merely pretending and gave him some more strokes to take in. The accused is thereupon charged with offense under 304. The jury found him guilty under 323. The session judge disagreed with the jury and being of opinion that the accused was guilty under 325, referred the matter to the High Court under 307 of the Old Code. In the aforesaid fact situation, the High Court held that the circumstances of the case, it was doubtful whether the accused had either intended or knew it to, likely that he would cause grievous harm, and as the case seemed to be on the borderline between 320 and 325, the accused might be given the benefit of the doubt and should be convicted under section 323. In the case of Ramakrishna Panikar versus State of Kerala, AI 959, Kerala so and so, before Kerala High Court, the victim was having a spleen of disease condition which got ruptured. In the said fact situation, Kerala High Court held that when the injury is not serious and there was no intention to cause death or grievous hurt, nor did the accused acknowledge that it was likely to cause grievous hurt or death, is guilty of causing hurt and not death, even though death is caused. It was further held that, therefore, where from the circumstances of the case, it is impossible to draw an inference that the accused would have intended to give the deceased anything more than a beating or thrashing to teach him a lesson for using foul language to him. A police officer, it would not be possible to attribute to him the requisite intention or knowledge merely because of the disease condition of the spleen of the deceased, which got ruptured. In such circumstances, his conviction at 304 cannot stand. A similar question arose before the division bench of Allahabad High Court in the case of Sri Prakash versus State, 1990 Criminal Law Journal 486. In that case, the beating given by the accused to a child has resulted in the death of a child. However, there was no visible injuries found on the dead body. Beating given to the child, therefore, could not be severe. On medical evidence, spleen of the child was found to be ruptured, and therefore enlarged spleen could only be the reason of death. The accused was not knowing of the enlarged spleen of the deceased. On the fact situation, the division bench held that the accused could not be held guilty under 304 IPC and further held that the conviction will be proper and 323 and not under section 325 IPC. Applying the principle laid down by three-judge High Court in the above referred judgments and the passages quoted by us from the medical jurisprudence of Dr. Modi and Dr. Jhala and Raju to the facts of the present case, it cannot escape from the conclusion the deceased Onkar died in an ordinary incident which was resulted into quarrel between the complainant and the accused party, and accused A1 and A3 Hajari got excited and gave lathi blows to the deceased whose spleen, as per medical evidence, was ruptured and it was enlarged and diseased. Therefore, neither intention nor knowledge can be attributed to the accused for causing murder of culpable homicide, not amounting to murder and disease Onkar. However, deceased has also received multiple fractures, so and so. Therefore, at the most of the offense under 325 IPC is proved against accused so and so. Lordship, may I check once again the medical report, minor postmortem report? Any other injuries are there or not? Page 49, my Lordship. Lordship may see owns position and character at page 50. One lacerated wound, 1 centimeter to half cm wide, is present on the left above elbow with a mild swelling and ecchymosis around it. One small bruise is present on the left leg above the knee. Mild ecchymosis is seen on the lower part of left chest. Dried fecal matter present on the anal region and the so and so is dry. Then scalp intact, skull intact, brain matter healthy. Then walls, ribs and cartilages, mild ecchymosis on the lower part of left chest. Then your lordship peritoneum at page 52. Liquid blood present on the left side of the peritoneum in and below the spleen area. Then spleen enlarged and soft and laceration and clot and liquid blood present. Then the more detailed description of the injury or disease at page 53. Laceration and bruises present on the left side of the limbs are already described. Mild ecchymosis on the lower part of left chest. Liquid blood present on the left side of the peritoneum in and below the spleen area. The spleen is enlarged and left with laceration and clot and liquid blood present. The findings are antemortem in nature. In my opinion, the cause of death is due to shock and hemorrhage following splenic rupture and hemoperitoneum. But one factor, your lordship, will keep it in mind, this victim died instantaneously, your lordship. So blow was severe. So in that event of the matter, if your lordship takes into account a 164 statement, lordship, since she was drunk, as a result of which there was quarrel and thereafter he beaten her up, benefit may be given to her, to him, your lordship, under 304, your lordship, part 2, my lord. Because beating was severe, she died instantaneously, my lord. And due to rupture of spleen, she died, my lord. If your lordship wants to give the benefit, that may be given to her. That is my respectful submission. If your lordship wants to bring the case under the general exception, my lord. That is my respectful submission.
Make this a lot. Your lordship, initially, my entire argument is whether the conviction could be based on the circumstantial evidence or not, because it was on that ground that the trial court has found the accused guilty and convicted. And I had reserved my argument on the confessional statement. Anyway, regarding the spleen injury, your lordship, I had placed on the last occasion that usually a normal spleen does not rupture unless there is a force of high magnitude force, like falling from a building or accident with a train. And that is what is recorded in the Modi also, and the judgment relied on by my learned senior. Also, it is only a blow can cause a rupture only if it is a enlarged or a soft, which is in the instant case it has been found. A blow can also cause a rupture of a normal spleen if there is some breakage of bone. That was recorded. That is what is recorded in the judgment. In the instant case, there is no breakage of bone. So the fact remains by falling or by blow. So there are two views possible. And the bamboo stick has not been examined. It's not been led to discovery under section 27. So the bamboo stick has not been proved that it was used for the murder. So that murder weapon is that bamboo stick is a murder weapon has not been proved by either by forensic, because blood was not examined, whether the injuries on the victim was because of using the bamboo stick. Nothing has been done apart from the confessional statement. So if we keep aside the confessional statement for some time now, the chain has not been completed as such, because the murder weapon has not been proved and the two theories are possible, two hypotheses are possible. So in that regard, I had placed my submission that he should get the benefit of doubt. Now regarding the confessional statement, your lordship, if your lordship sees page 58. He was produced before the magistrate on 24th. So till that time he was under police custody. On that day, though he was remanded to jail. However, since there was a prayer for recording of confession statement, it was allowed on that very same day. And from the police court premises, he was taken by a Havildar. So he was still under police custody to the magistrate who was supposed to record the confession statement. So he was produced before the magistrate who was PW7 at 12:30. So till 12:30, he was under police custody. And most of the judgment relied upon by the prosecution, lordship. Though 15-20 minutes was held to be permissible, but prior to that 15-20 minutes, the person giving the confessional statement, the accused in those cases, were under judicial custody for almost 2 days. They were not under the influence of the police. I will produce on judgment, Your Lordship, where one of the guiding principle of recording conference statement under 164 is that the accused should be free from the influence of police. He should be free from the fear of police. That is because he should ponder freely whether to give the conference statement or not. If he remains in the custody of police custody, even the mere presence of police officer, the police officer may not do anything, but even the mere presence will violate this 164 because the mere presence creates the fear psychic on the accused going to give the confession statement. Your Lordship, then I take the page 61. Page 61, right hand side down below, Your Lord. I was taken to so and so. I was sent to you from so and so. Having talked, this is the state magistrate statement also. Having talked with the accused, explaining to him each of the matters on the right hand side, mentioned in paragraph 5 here under, and caution him that he ought to reflect carefully before making any statement. I have placed him in charge of peon and armed police constable. He was still under the custody of police, and that too armed police constable. So the time reflection time given to him is a fallacy. The principle of 164 has not been complied at all. He was still in the custody of an armed police constable and directed the accused to wait in order that he may have time to reflect before making statement. So there itself, Your Lordship, no time was actually given for reflection. And then, Your Lordship, lastly, the confession statement itself, whether even if a Lordship takes the confession statement, can that be the basis of conviction, Your Lordship? If a Lordship see page 68, Your Lordship. Page 68, from the third line. Smith Munda, his wife, went out of his house and did not return home after long hours. She came back at about 8 p.m. Smith Munda came home drunk by consuming haria, country liquor, and I had taken some haria. We both had an alteration and both had verbal duels. She did not listen to me and used to quarrel very often in the past. When she consumed haria, she does not take food and starts quarreling. On 22/4/9, during our alteration at night, as my wife did not listen to me, I took one bamboo stick and beat her up. She fell down. This is consistent, Your Lordship. She fell down. That is a statement. I beat her up, but where in which body part is silent, nor there was any effort from the prosecution to find out. I beat her up and she fell down. So this remains constant. I then wanted to pick her up and put her inside the house. This is important, Your Lordship, because here the accused himself, the statement says the chain is broken itself from the statement of the. I then wanted to pick her up and put her inside the house. But at that moment, she ran away. She ran away. I went again to look out for her by the backside of her house. So she ran away from the house. So the chain is broken. So she is no longer with him. After beating her and she fell down, she ran away. She came back after an hour. I heard her noise asking for water. So she comes back after an hour. I went towards her and then I took water for her and brought her home. She was brought home and after some time she breathed her last. So even the statement, confessional statement doesn't say that I killed her. It is just a bamboo stick beating in which body part one doesn't know. And she fell down and she ran away for an hour. So what happened in those hours? And that is not been denied by the prosecution because prosecution is relying on this statement. Even if it, because during the 164 statement, he was under police custody. That has been from the record itself, Your Lordship. And even if we take the confessional statement, then itself it is also shown that she was not with him for an hour. And she comes back and she breathes her last. So the chain itself is broken. So on the basis of, also in the conference statement, also the accused cannot be found guilty. Because within 1 hour, what happened, nothing is on record. So my humble prayer is that he should get the benefit of acquittal. One is the he has given an explanation, because 106 cannot be applied because he's given a proper explanation, and that explanation is reasonable based on evidence and based on medical reason. Your Lordship, and regarding the confession statement also, all throughout he was in police custody. Even during his reflection time, he was in police custody. And secondly, even on the confession statement itself, that cannot also be the basis of his conviction. Because after falling down, which is consistent theory, and his version, the accused version also, she was not there for an hour. So that is my humble. And regarding this reflection time, the one Supreme Court, where it says, while laying down the principle of 164, during the time of reflection, the accused should be completely out of police influence. That is one of
Which judgment are you?
this. This is para, Your Lordship, 64. I've just given the relevant part. This judgment. This complete judgment also, I'll pass it on, Your Lordship. Page 60, paragraph 64, Your Lordship. Page 521. The following principle emerges with regard to section 164. And Roman 8 is the important. During time of reflection, the accused should be completely out of police influence.
Lordship, in our High Court rules also, Lordship, it's NV says the procedure, Your Lordship. Rule 23 of the High Court General Rules and Circular. How the 164 statement?
Is the High Court rules.
Lordship might not get it in this book, my the paper circular. I may be wrong, my lord. I take the other day. Circulars are there, my lord. আর এখন আসছে নাকি? Guwahati High Court General Rule and Circular Order, Chapter 1, Volume 1, Criminal.
One. Guwahati,
Lordship, it's page 64 of the paper book that it's there. I have studied carefully the provisions of Rule 23 of the High Court Rule General Rules and Circular Order, Chapter 1, Volume 1, Criminal. It's a
What is-
criminal.
it's
A separate
criminal.
book would be.
This is civil. Page,
Page 64. There's a format, Lordship. All these formats are NV says there. There's a form like, my lord, form number M84 rules. Form for at page 59 of the paper book. Form for recording confessions or statements and so and so. This is a form.
Those are my humble submission.
But, Sharma, Harsham. You amicus,
Isn't it?
Yes, yes.
let amicus curiae. Also heard MSM Buyan, B Buyan, when addition to first hearing concluded.
Obliged, sir.
Item 4. Leftover order matter.
Please, your lordship. Lordship, as far as the appeal is concerned, my lord, the paper book is ready. We have received the paper book, my lord. The IA is also fixed, my lord. If the learned senior is ready, my lord, maybe hard on the IA.
IS for suspension.
Suspension of
Yes.
sentence, my lord.
Sentence of
Sentence of
Lordship,
20 years.
live streaming be stopped.
40 p.m. And date of judgment is 12/4/19. So after the judgment, 4 years, he is behind the bar lordship after 4 years from the date of judgment. And this
date
is
of occurrence.
incident occurred on 25/9/2016 around 3:40 p.m.
Yes.
This is jail appeal lordship. Case is based on judgment is on basis of circumstantial evidence and only on the basis of extrajudicial confession, no eyewitness lordship. Although there is some extrajudicial confession is there, but those extrajudicial confessions also not corroborated by the investigating officer. Although the witnesses stated that they had intimated about the occurrence to the IO, but IO had in his cross denied those. So lordship, in that way, lordship, this case, there is no eyewitness also lordship. So may I read the Azahar first lordship? Azahar is by PW 5, Uttam Hajam. He is the elder brother of the deceased. Page 4 of the paper book lordship. Lordship, I have the honor to state that around 3:40 p.m. today, that is on 25/9/2016, while my younger sister Subola Hajam, aged about 35 years, was working in the house of the above noted accused, that is her husband, the above noted accused all on a sudden hit my sister on her neck by means of a dowel, as a result of which she fell on the ground and died on the spot. I came to know that when the neighbors immediately came there, the accused went towards the police station, taking along the dowel. I therefore earnestly pray to your good self to investigate the matter and take necessary action in this regard and oblige. PW 1, page 9, lordship. 1 Lankeshwar Rabha. I know the informant Uttam Hajang. I know the accused present in the court. I also know the deceased Subola Hajang. About 1.5 years back, the occurrence took place. On the fateful day at about 3 p.m., I was sitting in the village mandir with my friends. At that time, I heard that the accused killed his wife Subola Hajang by means of dowel. Accordingly, I went to the house of the accused. I saw the dead body of Subola Hajang lying near a bamboo bush situated at the house of the accused with neck injury. In the meantime, the police came and made inquiry of the occurrence. I did not find the accused on the spot. I heard that the accused was seen running with a dowel and shouting that he killed his wife. The police recorded my statement. Cross. When I reached the spot, I found the police present there already. It is not fact that I deposed falsely that I heard that the accused was seen running with a dowel
and shouting that he killed his wife. PW2 Anil Hajong. I know the informant Uttam Hajong. The accused Radha Mohan Hajong is known to me. Deceased Subola Hajong was known to me. Occurrence took place 1.5 years back. On the fateful day while I was walking in a tractor, I heard hue and cry in my house. My elder brother Deepak saw the occurrence and informed me accordingly. I went to the house of the accused. The police asked me to carry the dead body. The accused killed his wife. Cross, I have not seen the occurrence. It is not a fact that I deposed falsely that the accused killed his wife. Lordship, here one line is important, Lordship. According to PW2, my elder brother Deepak saw the occurrence and informed me accordingly. But Deepak was not a witness of this case, Lordship. He was not examined, Lordship. PW3, Pradeep Hajong. I know the informant Uttam Hajong. I am the elder brother of the informant. I know the accused person who is my brother-in-law. The victim, Subola Hajong, was my sister. The occurrence took place on 25/9/2016. The accused married my sister, Subola Hajong. My sister was married by accused about 7 years back. On the fateful day at about 3 p.m. when I alighted from the bus after returning from the market at Kumarikata, I saw the accused was coming with a dog on the highway with shouting. I heard that the accused was shouting the word he killed a person. I saw the accused was proceeding towards police station. I went to the house of the accused. I saw the dead body of my sister Subola Hajong having cut injury on her neck. The dead body was lying near a bamboo bush. In the meantime, the police arrived at the spot and took away the dead body. The dead body was sent for postmortem examination in the hospital. The police inquired about the incident from me. The accused killed my sister. Cross. It is not a fact that I did not state to police earlier that I saw the accused with a dog and shouting on the highway. It is not a fact that I have not seen the accused carrying a dog on his hand and shouting that the accused has killed a person. It is not a fact that somebody killed my sister and the accused carries the offending dog to inform the police. I have not seen the occurrence. It is not a fact that it is false that accused did not kill my sister. PW4 Girin Rabha. I know the informant. I also know the accused present in the court today. The victim Subola Hajong was married by the accused. The occurrence took place on 25/9/2016. On the fateful day at about 4 p.m. when I was in my home, I heard from the local people that the accused, after killing his wife, was proceeding on the road with a dog. Accordingly, I, along with local villagers, went to the police station and informed the police about the incident. The police apprehended the accused on his way to the police station. The police went to the place of occurrence and brought the dead body of the victim to the police station. The police seized the dog from the accused. The police inquired about the incident from me. Cross. I signed the Exhibit 1 at the police station. I have not seen the seized dog in the court today. I, along with Uttam Hajong and Naresh Hajong, went to the police station. This is also not corroborated by the police that Uttam Hajong, Girin Rava and Naresh Hajong went to the police station, Lordship. I have not stated to the police earlier that the police apprehended the accused on his way to police station. It is not a fact that I have not stated to the police earlier that the accused, after killing his wife, was proceeding on the road. It is not a fact that I have deposed falsely in the court today. I have not seen the occurrence. It is not a fact that since someone killed the wife of the accused for which he went to inform the police, but we blame the accused for killing his wife. PW5, the informant, Lordship. Here, Lordship, PW3 and PW5 are the elder brothers of the deceased, Lordship.
PW3
and PW5. I am the informant of the case. I filed the Azahar of the case. I know the accused person. The deceased Subola Hajong was my sister. About 11 years back, the deceased was married by the accused. The occurrence of this case took place about 2 years back. On the fateful day at about 3:30 p.m. when I returned to my home from market, some villager reported me that the accused was proceeding on the road by shouting that he killed a person. The accused was seen coming towards the police station. My niece Gita Hajong informed me that her father accused killed her mother Subola Hajong. Lordship, Gita Hajong is also not examined in this case, Lordship. informed me that her father accused killed her mother, Subola Hajang. Hence, I went to the house of the accused. I saw that the dead body of Subola Hajang was lying near a bamboo bush with cutting of her neck. The police was informed who came and shifted the dead body for postmortem examination. Accused produced the offending weapon, namely dao, before the police. Police seized the dao. I went to police station and filed the ejahat. I saw the accused present in the police station. Cross. The police inquire about the incident from me. It is not a fact that I did not state to the IO that when I came from market, the villager reported me that the accused was proceeding on the road by shouting that he killed a person. It is not a fact that I did not state to the IO that my niece Gita Hajang reported me that her father accused killed her mother, Subola Hajang. It is not a fact that I did not state to the IO that after getting information of the incident, I went to the house of the accused and saw the dead body of Subola Hajang near a bamboo bush with cutting of her neck. It is not a fact that I have deposed falsely in the court today. I have not seen the occurrence. It is not a fact that I have not seen the accused proceeding towards Thana on the road by shouting that he killed a person. I have not seen the seized down in the court today. It is not a fact that when the accused went to police station to report that his wife was murdered by someone, I implicated him falsely in the case. It is not a fact that out of grudge, I filed a false ejahat against the accused. PW6 is the doctor who conducted the postmortem examination. On 26/9/2016, I was working as medical officer and health officer at Robi Boro Civil Hospital, Musalpur, and on that day, with reference to Tamulpur police station case number so-and-so, I performed postmortem examination on the dead body of Subola Hajang, aged about 35 years, and found the injuries as follows. Cut injury over neck extending from skin muscle, trachea, asparagus, blood vessels, cervical vertebra, only skin part on back and left area. Cut injury just below left breast, bone deep 3x4x5 rib exposed. Cut mark skin deep on left interior axilla, 4x3x2 centimeter. Cut mark left forearm, skin deep 4x2x2 centimeter. In my opinion, cause of death was due to shock and hemorrhage due to sharp cutting wound on neck. Time since death is within 24 hours. All the injuries are antemortem in nature, caused by sharp cutting weapon. Other organs are normal. PW7 is Naresh Hajang. I know the informant of the case. I know the accused Radha Mohan Hajang. I know the deceased also. The occurrence took place about 2 years back from today. On the fateful day at about 3:40 p.m., I arrived from Guwahati and saw that the accused was proceeding on the road towards Thana by shouting that he killed his wife. The accused was carrying a dao on his hand. Immediately, I informed the Gaon Bura who reported it to the police. According to police lordship, he was informed by one journalist, but not Gaon Bura. But here, according to him, he is Gaon Bura, who reported it to the police. The police came to the place of occurrence and shifted the dead body to the police station. The police inquired about the incident from me. I saw the cut injury on the neck of the deceased. Cross. It is not a fact that I did not state to the police earlier that on the fateful day I arrived from Guwahati and saw that the accused was proceeding on the road towards Thana by shouting that he killed his wife. It is not a fact that I have deposed falsely that the accused was seen on the road by shouting that he killed his wife. It is not a fact that I did not state to the police earlier that I informed the Gaon Bura about the incident. It is not a fact that I stated to the police earlier that I was in my home at the relevant time as there was none present in my home. It is not a fact that I stated to the police earlier that I guessed that accused might have killed his wife. I have not seen the occurrence. It is not a fact that the accused was proceeding towards Thana by shouting that his wife was killed by someone. It is not a fact that in spite of knowing that accused did not kill his wife, I deposed falsely to implicate the accused in the case. PW8, Narayan Rabha. I know the informant of the case as well as the accused. I know the deceased Subola Hajang. The occurrence took place about 2.5 years back from today. On the fateful day at about 3:30 p.m., the accused, after killing his wife by means of a dao, was seen coming to the police station by road with the dao and shouting that he killed his wife. Accordingly, the accused surrendered before the police and confessed his guilt. At that time, I was present at the police station. The police seized the dog from the accused by so-and-so. The police inquired about the incident from me. Cross. The house of the accused is at a distance of 1.5 kilometers from my house. I have not seen the murder of deceased Subola Hajam. I saw the accused at night at the police station. Incident is of the evening time, Lordship, and he saw the accused in the police station in the night only, Lordship. I have not seen the seized dog today in the court. I saw the seized dog at about 7:30 p.m. At the police station. I have not seen from whom the police seized the dog. It is not a fact that Exhibit 1 was blank at the time of my signature thereon. I cannot say the contents in Exhibit 1. It is not a fact that I have put my signature in Exhibit 1 without knowing the seized article. It is a fact that I did not state to the police earlier that the accused came to the police station with a dog by shouting that he killed his wife, as the police did not ask me such question. The last PW9 is the IO, Lordship. May I read, Lord?
Yes.
On 25/9/16, I was posted as second officer of the Tamulpur police station, and on that day at about 4:20 p.m., one local journalist informed me over phone that a local woman was murdered by a man. Accordingly, I lodged a GD entry at the police station and went to the place of occurrence with my staff. On my way, I found that the person who murdered the woman was coming towards police station with a dog, shouting that he killed the woman and other local person were chasing him. Hence, I apprehended the said person with the dog and brought him back to the police station. On my inquiry, the said person disclosed his name as Radha Mohan Hajam. Immediately, I handed over the accused with the offending dog at the police station and rushed to the spot. I went to the house of the accused Radha Mohan Hajam and found the dead body of his wife lying at the courtyard. The dead body had mark of cutting of the throat. I informed my superior officer and executive magistrate about the occurrence. I recorded the statement of the witness. The local witnesses disclosed to me that the accused cut off the neck of his wife, Subola Hajam. I prepared a sketch map of the place of occurrence. In the meantime, the situation at the place of occurrence became tense and deteriorated. Hence, I brought the dead body from the place of occurrence to the police station. I inquired about the incident from the accused. The informant Uttam Hajam lodged the FIR. On next day, the executive magistrate Aditya Gugu so-and-so. I seized the dog fight so-and-so is my signature. I sent the accused to judicial custody after his arrest. I sent the dead body to hospital for his postmortem examination. Subsequently, I collected the postmortem report. At the end of investigation, I filed a charge sheet against the accused. Cross. I recorded the statement of the witness on the same day at the place of occurrence. I seized the offending dog at the police station in presence of witnesses. I did not record confessional statement of the accused made before me through the magistrate. So, Lordship, although he was sent to judicial custody, but thereafter his confessional statement was not recorded, Lord. Witness Pradeep Hajam did not state to me that the accused was running on the road with a dao bar shouting, but he heard about it. Witness Girin Rabha did not state to me that the police apprehended the accused on the road and did not state to me that the accused, after killing his wife, was going on the road with the dao. Witness Uttam Hajam did not state to me that Gita Hajam told him that the accused killed her mother. It is not a fact that I filed a charge sheet against the accused on the basis of suspicion without going through proper procedure of investigation. Now, Lordship, there are 313 statements of the accused was recorded, Lordship, which is of total denial, and according to him, the case has been filed bringing false allegation against the accused person, Lordship. But this is the only evidence, Lordship, against the accused, that there is only some said that he was running in the road, shouting that some said that he shouted that he had killed someone, some shouted that he had killed his wife, Lordship, and no eyewitness, Lordship. Though though they stated that they had learned from some Deepak and also from the daughter of the deceased and accused, but they were not made a witness of this case, Lordship. No confessional statement of the accused was recorded, Lordship. So on the basis of only that extrajudicial confession or maybe before police, Lordship, and there is no circumstantial evidence to the chain of any circumstantial evidence, nor there any witness had stated anything, any motive, the reason of killing, any quarrel, nothing, any demand of any dowry or anything, nothing, no reason of killing, Lordship. That much evidence is only there that they had saw the accused running. And yes, that question was also asked, although they denied that he had, after coming to know that someone had killed his wife, he had just went to the police station to inform with a doubt. That much is there, but perhaps that is the actual story of the case, Lord. That he, after coming to know that someone had killed his wife, he went to the police station to inform about the incident, Lord. And all the witnesses stated that someone coming at the same time from market, someone coming from Guwahati, someone from here and there at the same time, and they just saw the accused, Lordship, running on the road or coming to the police station with the. That much is the only evidence, Lordship. Here he was already, the incident is of 2016, Lordship. We are in 2023, Lordship. There is no other evidence to that in my humble submission, Lord.
What is the finding of the trial court?
Finding, Lordship. Paragraph 33, that circumstantial evidence is discussed, Lordship, not case is discussed in the light of circumstantial evidence, Lordship, but in this case, Lordship, there is no such circumstances. There is no chain of circumstance, Lordship. The chain has to be complete, Lordship. Here is no such chain of any circumstantial evidence, Lordship. Case laws were discussed, Lordship, but this case, in my understanding, Lordship, doesn't fall under that, Lordship.
Yes.
Case laws of circumstantial evidence discussed, Lordship, and some extrajudicial confessions part was discussed in paragraph 46, Lordship. And on the basis of that, Lordship, the observation,
Read para 35 of the judge.
Lordship. Apparently, the circumstantial evidence was projected by the prosecution in this case against the accused is that on the fateful day in the afternoon, the accused was seen proceeding by the road towards the local police station with a message on his hand. That circumstance appears to be not sufficient enough to implicate the accused in the occurrence. Further, the prosecution placed another circumstances which shows that the accused was shouting that he killed his wife or public person and he was seized by local public. This circumstance is corroborated by the IO in the evidence. The IO stated that while he came out of the police station to go to the place of occurrence after he received the information that a man murdered his wife or person, he found that the accused was coming on the road with a dao on his hand and the accused was chased by local public. Hence, the evidence of PW5, though he was not an eyewitness of the occurrence, cannot be disbelieved. PW5 disclosed similar circumstances as stated by the IO in the Exhibit 5, the Ejahar. Lordship, PW5 is the informant, Lordship. He had also stated that from Gita Hazang he learned that the accused had killed his wife, but Gita Hazang was not examined. And he was not there, Lordship. According to PW5, Lordship, on the fateful day at about 3:30 p.m. when I returned to my home from market, some villager reported me that the accused was proceeding on the road by shouting that he killed a person. The accused was seen coming towards the police station. My niece Gita Hajang informed me that her father accused killed her mother, Subola Hajang. Hence, I went to the house of the accused. I saw that the dead body of Subola Hajang was lying near a bamboo bush with cutting of her neck.
One thing is there, that all the PWs, they are consistent in saying that he was running with the dog towards the police station.
Lordship.
And then some PW has said that the public was chasing him. And the IO also said that he was being chased
Lordship.
by the locals. Now, if you accept your theory that he was taking the knife, the dao to the police station, that someone had killed him and he was going to give the dao to the police. Why should he be the
Lordship.
locals chasing?
None from the neighboring people who had actually seized him. If we go to that he was seized by a person, Lordship, no witness was there. The villagers who actually had seized, none was examined. They came to know that some were seizing, but who is actually chasing, Lordship? PW 3 and 5 are the two brothers of the deceased, Lordship. So here, Lordship, motive is not there. No one had seen the girl Gita Hajang, the daughter. She was also not examined. So circumstance only to that one person is running with a dao. That much is the only circumstances. That the circumstance begin only from their Lordship. That cannot be connected with the offense, Lordship. There is no connection with the offense. Had Gita had said that yes, my father had killed, then he ran, then the circumstances, the chain will be there, Lordship. But the chain starts only, some said that he ran along with a dao, Lordship. The circumstance doesn't implicate him with the offense, Lordship. Circumstance only to carry the message. From that the circumstance start. Here the circumstance is not, the chain not begin from the offense, Lordship. And although those part, Lordship, there is possibility that it is only an improvement, Lordship, because the saging part, the saw and the witnesses saw the accused running, those part, as per the IO, Lordship, they had not stated to the IO, Lordship, at that time. In cross, IO had denied that they had stated that. Those part is an improvement, in my opinion, Lordship, because IO had in his cross stated that Pradeep Hajang, Girin Rava, and Uttam Hajang, they have not stated those part to the IO at that time. But that is only thereafter, Lordship. They have stated that they had saw. Actually, who had chased him? No one had chased him. Saging part, if there are village people, Lordship, some must be that I have chased him, we have chased him. Those part were not there. They came to know that some of the villagers chased him, these part are there, but actually these people was not there. They are coming from other direction or maybe from some different places. So they have not chased him. The chasing part, Lordship, actually these witnesses have not chased him. And no person, if says him, they are not a witness. So chain doesn't begin from the offense. The chain is only from some from that point of that some had saw him running with a dao. The chain is not here, and confessional statement was also not recorded. So those part are there, Lordship. It's Lordship. Lordship. And nearby, Lordship, if I see the sketch map, Lordship, there are neighboring people's houses are there, Lordship, but those people were also not examined. Have there been any shouting, any incident? Those persons should have been there, Lordship. The sketch map page 54 shows the house of one Ajit Hajang. But Ajit Hajang, neither Ajit Hajang was examined, nothing, Lordship. This sketch maps shows that, Lordship, house is B is the house, and the dead body was lying in A, Lordship. It is page 54, Lordship. It is not inside the house, Lordship. It's a bamboo bush, Lordship. And the dead body was found near the bamboo bush. near the river bank, Lordship. It perhaps the courtyard, but not inside the house, Lordship. So it cannot be overall that somebody had come and cut the deceased, Lordship. Could not do that inside the house. Lordship, it's the incident, the dead body was found near the bamboo bush, near the river, Lordship. So it's not inside the house or in fact, other person's house are nearer to the place of occurrence, Lordship, where the dead body was found, Lordship. It's my that Lordship, there is no eyewitness, no direct evidence. The scene is not complete in this case, Lordship.
You want to say there's a missing link.
Lordship.
Lordship, there are two circumstances which goes against the accused person. One, that he was shouting that he had killed someone. And the other one, he went to the police station with the weapon in hand, my lord. There are two witnesses, reportedly Gita and Deepak. Reported witnesses, they have not been examined, your lordship. There's lapses on the part of the prosecution. There are material witnesses, my lord. But I have checked the charge sheet also. They were not cited as a witness, my lord. Lordship, may I pray for the end of justice by exercising the provision under 311 of CRPC? Your lordship may direct the learned court below to take evidence of these two witnesses. May I take your lordship to the 311 CRPC, my lord? Any court may at any stage of an inquiry, trial, or any other proceedings under this code summon any person as a witness or examine any person in attendance who not summoned as a witness, or recall and re-examine any person already examined, and a court shall summon and examine or recall and re-examine any such person if his evidence appears it to be essential to the just decision of this case. Here, Gita, her mother was killed, your lordship. She has reported to lordship the informant PW5 about the killing. Her mother has been killed by her father, your lordship. Then she has reported that matter, but she has not been cited as a witness. As well as the other one, Deepak, my lord. Lordship, Deepak informed PW2. Deepak saw the occurrence and informed, my lord. If your lordship takes up the evidence of PW2, here he was informed by one Deepak, my lord. He has not been cited as a witness. Lordship, page 10. I know the informant Uttam Hazang. The accused Radha Mohan Hazang is known to me. The deceased Sobola Hazang was known to me. The occurrence took place 1.5 years back. On the fateful day, while I was walking in a tractor, I heard hue and cry in my house. My elder brother Deepak saw the occurrence and informed me accordingly. I went to the house of the accused. The police asked me to carry the dead body. The accused killed his wife. I have not seen the occurrence. It is not a fact that I deposed falsely, that the accused killed his wife. So in this case, Deepak, he informed PW2, my lord, Anil Hazang. He has not been cited as a witness, your lordship. The charge sheet.
You're praying for that.
Yes, I
Prosecution
am
is
praying for that, my lord. Yes. To arrive at a just decision of the matter, my lord.
Hurt.
Lordship, it's a case of 2016, Lordship, already behind the bar, and that is the prosecution's fault, Lordship. Any benefit that should go to the accused, Lordship.
Lordship, within a period of 1 month, it may be our examination, their examination be
We'll see.
taken up.
Let them do it in a period of 1 month.
Lordship.
Hurt. Bishop.
Bishop.
Well, deep breath. This appeal from jail is again. This appeal from jail, can you have it? Is directly against the judgment dated 12/4/2019, passed by the learned Sessions Judge Bakshat in Sessions case number 52/18 within bracket all number 46/17 under section 302 IPC, whereby the appellant was convicted and sentenced to undergo where's the sentence? Rigorous imprisonment for life with fine of ₹5,000 in default, simple imprisonment for 6 months under section 302. While appreciating the evidence during the course of time, during the course of hearing, and while appreciating the evidence, comma, we find that the PW2 in his deposition has stated that his elder brother Deepak saw the occurrence and informed him accordingly. Further comma, deposition of PW5 indicates that his niece Geeta Hajun informed him that her father killed her mother, Subala Hajun. Stop. We find that the two prime witnesses, namely Deepak, is it Deepak Hajun
Yes, ma'am.
or just say Deepak?
Because he is his brother. It will be
His
Hassan.
brother is Hajong.
So it has to be Deepak Hajun.
Yes,
Deepak Hajun and Geeta Hajun
Gita Hassan.
were not examined. Stop. At this stage, Leonard additional PP, MSB Buyan, press before this court to allow the prosecution to examine the said two witnesses.
They are not witnesses.
They were not cited as
The said
witness.
two persons, namely Deepak Hajun and Geeta Hajun. Stop. After considering the submission made by the learned additional Vyasa and on perusal of and on appreciation of the evidences, comma, we also find that the evidence of the said Deepak Hajun and Geeta Hajun should be examined by the court below. Stop. accordingly, we direct the learned sessions judge, Baksha. Correct?
Yes. Baksa Lordship.
Baksha,
Yes. Baksha Muchalpur.
comma, Mushalpur, to examine the said two persons, namely Deepak Hajar and Gita Hajar. Within a period of 1 month, within a period of 1 month from the date of receipt of a copy of the order of this stop. Drafted the evidences of the said Gita Hajar and Deepak Hajar shall be forwarded to this court. Stop. This the matter again after 6 weeks. Since we're
Yes.
giving them 4 weeks, it
Yes.
has to be 6
No.
weeks. This the matter after 6 weeks. Registrar is directed to furnish a copy of this order to the learned sessions judge Baksha, Mushalpur. Stop.
Thing is that Lordship, trustworthiness of their evidence that will be their Lordship. Now definitely Gita either be with her maternal uncle's house, or I don't know what is her age, Lordship. And now how much trustworthiness will be their evidence? That has to see, Lordship.
That-
Applies, Lord.
You want to expand the order? That is- okay.
Well,
May I please, Your Lordship? I'm appearing on behalf of Mr. A. Kalida. Lordship, he has some personal difficulties, so kindly pass over for the day and fix a date.
Why have you not informed earlier? You informed the public prosecutor.
Yes, Lordship, sometime
You may
before.
pass on. After 10:30.
You should at least inform 1 day advance. You know the notification is there. On request made on behalf of Anjan Kalita, learned amicus curiae. List the matter up to 2 weeks. MSB Buyan, learned addition PP is for us, is present for the state of Assam.
Lordship, can I fix a date?
No,
Of
you
like-
want an adjournment and you want a date fixed.
13.
Mr. N. Hassan was waiting for his matter. I don't know where did he go now. It's not there.
He was present earlier.
Lordship,
He was present earlier.
he was there in the court in the morning. He was speaking to me about the case. Here, one thing, even I have to, because I have seen the case in the court today. So I have to bring few decisions, because here is a case where the girl had eloped with the accused, with the appellant on her own will, because her parents were not allowing her to get married to this appellant. And she was, of course, minor. There was a radiological test. Radiological and ossification are not the same thing. On the basis of a radiological examination, the doctor said she was below 16 years.
Also,
POXO. So in fact, she perhaps was a minor, but I think there are few High Court judgments on live law I have seen. Delhi High Court, Calcutta High Court, where it is said if the girl can show that her parents have tortured her in a way, and she was forced to elope with the person she says she is in love with, then in those cases, unless the prosecution can show he allured her, he enticed her, he forced her to go with him, I think there are few judgments. Those judgments I don't have. Even Hassan, I'll bring those judgments. Because for nothing a person is inside. 20 years imprisonment. Hassan was here, was very much here.
learned amicus curiae is absent. On request made by MSS Jahan, learned addition PP Assam, list the matter after 2 weeks.
2 weeks, I'll get those
2
judgments.
weeks.
Supreme Court, I'm not sure. High Court, I've seen few judgments on that.
15.
May it pleases your lordship.
Arunachal.
Arunachal. My lord, before I take your lordships to the evidentiary part of this case, my lord, let us agree in principle one proposition that a confession recorded, if a confession is recorded after 4 days of police remand, straight from the police station, if a man is brought before the magistrate after 4 days of police remand, will that confession be regarded as a valid confession for the purpose of convicting an appellant under 302? In my respectful understand, probably the answer is an astounding no. Here is a case where the entire conviction is based on a confession, and interestingly, the confession was recorded on the date when his police remand expired. My lord, before I go into PW1, PW2 and all this Caesar list, I take your lordship to 2 order sheets which I have marked, flag marked in pink color. He was arrested on 24th. He was produced before the, not this, my lord, from the record, original record. I have just perused, my lord. এই রেকর্ড তো দিও না দাদা, এই যে এই দেখো পিঙ্ক কালার যেটা ফটো রেকর্ড from the lower court record, my lord, pink, 2 flag marks in pink color. And then, my lord, I will take your lordship to the FIR and the PWs and everything. These are the 2 flag marks. The later one, yes. Your lordship will see the vertical one was when he was produced first after arrest. He was produced on 25th after arrest. He was arrested on 24th. He was produced on 25th. 4 days police remand sought. He was granted 4 days police remand, and he was directed to produce on 29th. Now, my lord, will see the horizontal flag mark. On 29th, what happened? On 29th, what happened? He was produced before the magistrate on 29th at 11 a.m. by the police after expiry of the police remand. And then the magistrate directs him to produce at 4 o'clock. There is no direction to send him to anyone, either to judicial custody. On the same day, his confessional statement was recorded at 4:15. 4 o'clock, 11 o'clock, he came along with the police. Magistrate said, bring him again at 4 o'clock. 4 o'clock he came. 15 minutes reflection time was given, and a confession statement has been recorded. And this man is in custody since last 7 years. This is my case. The entire case is based on 2 pieces of evidence. One is this confession statement, which is absolutely hit by the principle laid down under 164 and as expounded by the Honorable Apex Court. And one disclosure statement that I have disclosed. Now, my lord, this little paper book which I have prepared, my lord, if your lordship comes to the disclosure statement, because I'll touch these 2 evidence and then I'll go FIR and PWs and all these things. The disclosure statement, if your lordship kindly comes to page number 47 of the paper book, page 47. My lord, this is the disclosure statement. Your lordship is there at page 47?
Yes.
My lord will see very conveniently, and for reasons known to the IO, the column date and time is missing. It doesn't, neither the date or the time he has signed somewhere beneath his signature, nor the date and time is mentioned in, whereas there was a specific column to that. My lord, it reminds me of 114 of the Evidence Act, illustration G. This calls for an adverse inference, my lord. These are the 2 pieces of evidence, my lord. And since the date of the incident, he is in custody. Even his bail was denied. He is languishing in the jail of Arunachal, my lord. leaving behind his family and everything, my lord. Now I come to the evidentiary part of the case. Now, before I take your lordship to the FIR, I'll just give an idea as to how this case has culminated. Now, here the prosecution says that this accused person, he had an illicit relation with the wife of the deceased. So a motive was attributed to him. They said that he had an extramarital affair with the wife of the deceased. And because of that, he considered this deceased as a hurdle in their relationship. And therefore, one fine day, when the dead body of the deceased was recovered from a jungle, they have placed the entire blame on this man, saying that it is you who have done it. This is the prosecution case. Now, my lord, the affair was lost by the brother of the informant. Brother of the deceased. My lord will kindly come to the FIR. The FIR is at page number 6. Page number 6 is the FIR, my lord. Type copy your lordship will find at page number 7. With reference to the above cited subject, I would like to lay my grievance that my younger brother, Manthai Mosang, age 35, is an employee of government of Arunachal Pradesh under SSA and his posting place is Government Middle School, Newton. On 21/12/16 at around 8 hours, he left his quarter in his car, I-10, for duty at Newton, but he did not return in the evening. Accordingly, we had searched him in Miao Town and nearby villages, but we could not trace him yesterday evening at around 10 hours. His wife, Srimati Nongung Mosang, had verbally reported a missing report at Miao police station. Today morning at around 10 hours, his dead body was found in his car near TR campus, TR camp, Tri-Junction, Mayo. It is purely of murder case. Hence, it is requested. This FIR was lodged on 22/12/2016 at 10:45 hours. Now, to bring home the guilt, my lord, the prosecution has examined as many as 8 witnesses. Out of the said 8 witnesses, my lord, the official witnesses are the IO, the medical officer who have conducted the postmortem, and the magistrate who has recorded the 164 statement. These are the 3 official witnesses, the informant and the wife of the deceased and 2 neighbors. They are immaterial, my lord. They does not lend any credence either to the prosecution or to the defense. So in connection with this FIR, this gentleman was arrested on 24th, my lord. My lord will condone, my lord will find the arrest memo at page number 12. In fact, this arrest memo relates to the wife of the deceased, who was also one of the accused, but charge sheet was not filed against him. Her. Now, PW1, that is the informant, at page number 1313.
PW
1.
page
13. That is the brother of the deceased. He is the informant. Is basically an hearsay evidence for most of the things, my lord. On 21/2016, I have got information that my younger brother, namely late such and such, has not returned back from his duty after attending his duty. At around 9 p.m., I was called by my sister, namely Miss such and such, from her mobile, and I have taken her sister-in-law and I have talked with sister-in-law, that is wife of such and such. On 21/1/2016, I, along with some of my relatives from such and such, proceeded to Miao at the residence of my deceased brother. On my arrival, I have seen my sister-in-law was talking to someone over phone. I inquired her regarding any information of my brother. She replied with she has not got any information. I inquired as to whether FIR is filed. She replied that she informed the matter to police. I was surprised to observe that my sister-in-law was not having any trauma, even though her husband did not return back. I have entered into the residence and seen that lots of our relatives were inside the residence and praying. Thereafter, I have proceeded to the PS Miao. I have met EAC Miao at the PS. I was informed that even after their best effort, no information could be found regarding my brother. After about few minutes, one information is received at PS that the vehicle of my brother is standing nearby the TR camp area and one dead body is inside the vehicle. On receiving the information, the police team and EAC rushed to the spot. We have also followed the team. On receipt of the spot, I have seen that the vehicle belongs to my brother and my brother is inside the vehicle on driving seat. My lord, I'll take a pause here and I'll like my lord to kindly mark this word where the dead body was found. Inside the vehicle on the driving seat. Police has opened the door of the vehicle in my presence. I have seen the dead body of my brother on the driving seat. Twice he has confirmed it, that the dead body was in the driving seat. There is a mark on the neck which show that his neck was tied by the seat belt of the vehicle. I have also seen blood stain on the abdomen area of the body. On observation, I have seen mark of passing human towards the jungle nearby the vehicle. Police have observed and taken the dead body of my brother to the hospital of PME. As it was evening and team of doctor was not there, the PME could not be done on the same day. On 22/12/2016, PME was done at about 1 p.m. The dead body of my brother was handed over to me. I have taken the body to my village and observed final rites. Now, my lord, after observation of my last rite of my brother on 23/12/16, I went to Miao police station. I was asked by the police to bring. Now, my lord, after observation of my last rite of my brother on 23/12/2016, I went to police station. My lord, if I understand this sentence correctly, that after the last rites, he performed the last rites of his brother, he went to the police station on 23. So on 23, he went to the police station. That is my understanding of this language, my lord. After observation of my last rite of my brother on 23/12/16, I went to Miao police station. I was asked by the police to bring my sister-in-law to the police for interrogation. Accordingly, I called my sister-in-law to Miao PS on 24th. On PS, I have come to know that police has arrested accused Suman Biswas, who was a driver and used to have a good relationship with the deceased brother and family. It came to my knowledge that my sister-in-law had relation with Suman Biswas. My lord, I'll have to take a pause here, my lord. There are two dates which has some bearing on this case, my lord. Now here he says that after the last rite, I went to the police station on 23rd of December. Then he says that at police station, the police informed me that you should call your sister-in-law. Then he called his sister-in-law that you attend police station on 24th. He told the sister-in-law that she should come on 24th to the police station. Now on police station, in the police station, that is on 23rd, when he went to the police station. In the police station, when he visited the police station on 23rd, he has come to know that the accused was already arrested. Why I am saying it, my lord? My lord will see how this man was tortured. I'll take your lordship to the 313 statement. How this man was. He was actually arrested on 23rd. The arrest memo was prepared on 24th. Then he was produced before the magistrate on 25th. Then 4 days remand. Then 29th confession. That is why, my lord, I was stretching on these 2 dates. Because here this PW1 has incidentally or coincidentally, my lord, he has spelled it out. That on 23rd, I went to the police station. And then he said the police told him that you should call your sister-in-law on 24th. He called the sister-in-law. He gave a call to his sister-in-law and said you should visit police station on 24th. Therefore, on 23rd, when he had visited the police station, he has already come to know that this Suman Biswas was arrested by the police. Next, I was informed by police that when my brother was driving his car on the way, accused Suman Biswas had stopped his car and requested for lift to TR camp area for meeting some person. While returning for TR camp area, my brother has inquired Suman Biswas as to why he is having affair with my sister-in-law. There was argument between the brother and the accused has killed my brother. I have also come to know that my brother was killed by the accused with a knife. The accused person has disclosed that he has thrown out the knife and the mobile of my brother towards the jungle on the place of occurrence. As per disclosure of accused Suman Biswas, police has recovered the blood stain of the knife and the mobile of my brother from the jungle of the PO. Now, my lord, this part of the evidence is purely hearsay because he says police have informed him. So this part of the evidence, I'll not stretch much on it because this is purely hearsay. On my inquiry to the, on my, even this, the paragraph which I'm about to read is also a hearsay. On my inquiry to the housemaid of my brother, namely Sumi Moran, who is not being examined, who stayed with us for about 3 months after the death of my brother, has told me that whenever my brother goes out for attending duty, accused Suman Biswas used to come, and both of my sister-in-law and Suman Biswas used to lock themselves inside the bed, and a housemaid and the child used to stay outside. I have also come to know from my sister-in-law that the accused person, namely Suman Biswas, had extramarital affair with my sister-in-law. Many occasions, both my sister-in-law and accused person used to go out together from the residence of my brother. I came to know that the extramarital affair between my sister-in-law and the accused came to the knowledge of my brother, for which the accused person has killed my brother. My sister-in-law was also arrested in connection with the present case, as she was also involved for the death of my brother. The accused person standing on the dock is identified by the witness. Exhibit 1 is the FIR, Exhibit 2 memo, taking over dead body. Exhibit 3 is the seizure memo, cross. Before the incident, I did not know the person, and I came to know him after the arrest. I have not seen the accused person killing my brother. Before the incident, I have not seen the accused person with my brother. Now, my lord, I was trying to find out, I have my doubt whether this man was defended by a counsel or a counsel, definitely by a counsel. What I'm saying, by a private counsel or a legal aid counsel, because the cross-examinations are terrible. 2-liner, 3-liner cross-examination in a murder case. This man was not even defended properly because he was inside the custody, far from his hometown. Page number 16 is the PW2 is the sister of deceased.
This will continue at two.
Absolutely. Absolutely.
Lordship, I'm sorry, in item number 13, I could not appear, Lordship. I was in court number 21, Lordship. So Lordship has directed to be the matter to be listed after 2 weeks. My name may be reflected, Lordship.
Item
13, 1-3, Lordship.
N. Hassan.
Lordship.
Just say N. Hassan.
Obliged, Lordship.
Council of our High Court.